Welcome to Insights on Estate Planning, Spousal Lifetime Access Trusts. My name is Michael Clear, and I'm a partner at the law firm of Wiggin and Dana. And I am joined today by my partner, Carolyn Rears.
Hi, Mike.
Our goal today is to have a conversation surrounding spousal lifetime access trusts, or commonly known to or referred to as SLATs. Carolyn, maybe you can just give us an overview of a SLAT.
Sure. A SLAT is a trust that's created not only for the benefit of someone's descendants, but the trust also provides that the spouse is a beneficiary during his or her lifetime.
Why are SLATs so popular today from advisors, referral sources, and accountants?
We're hearing a lot about SLATs today, in particular because of where we are with the federal gift and estate tax exemption. Currently, we have an extremely high federal exemption of $11,580,000. It's the highest the exemption has ever been, and it's scheduled to sunset on December 31st of 2025. So there's a limited window during which people can use this extended exemption. So for a married couple who each have the exemption, they can put roughly $23 million into a trust under the current high exemption amount, which is scheduled to be decreased probably by half on January 1, 2026. And that could happen much sooner depending upon the outcome of the election this year. Almost all of the Democratic candidates during the primary included in their tax platform rolling back the 11 million to half of that sooner than 2026, and perhaps even bringing it back to $3.5 million, which was the exemption in 2009.
So the SLAT then is an irrevocable trust that we're going to create to receive that gift, and it's special because the spouse is going to be a beneficiary.
Exactly. So $23 million is a lot of money. Mm-hmm. And the reason we're talking about these trusts is that typically when a couple wants to use their exemption amount, we've put the exemption into a trust for the benefit of the descendants because, as you just noted, the gift is irrevocable and it's a long-term planning tool for the family because once the assets get into the trust, all future appreciation and growth is outside of the estate and gift tax system, no matter when they die. So normally those trusts are for the benefit of descendants and the long-term family planning. $23 million is a lot of money for people to part with, even though they hate to lose the opportunity to use this higher exemption amount. So the solution is adding the spouse as a beneficiary of the trust so that if the couple wanted to receive some benefit from the trust, it's possible to make a distribution to the spouse that could effectively benefit the couple.
So it kind of we've jumped into our idea of kind of how do we go ahead and design a SLAT. And some of these features are features that we discuss often with anytime we're doing gifting to an irrevocable trust. And as you already mentioned, the beneficiary selection here is what makes the SLAT special.
That's exactly right. Yes.
Including the spouse. So what are some of the other design factors that you consider as working with a client?
So obviously the beneficiary is the first thing that we talk about. We also talk about what the distribution terms are. Are distributions made pursuant to a standard, for example, only for health or education? Or can distributions be made for any reason whatsoever? The broader the distribution standard, the more careful we have to be about who the trustee is. Because although it's possible to name a beneficiary as a trustee, the broader distribution standards will require that there also be an independent trustee, either as a co-trustee or a sole trustee, independent being somebody who's not a beneficiary and usually not related to or employed by the settlor or beneficiaries.
So when,
And then we also, sorry.
so when you're creating a slat, we have the beneficiary has the spouse. What are some of the, if you also want the spouse to serve as one of the trustees or maybe the only trustee, what sort of distribution terms do you use?
In order for a spouse to be a trustee and the only trustee, the distribution has to be limited to something called an ascertainable standard, which is actually defined in the Treasury regulations. And that is health, maintenance, education, and support in a custom manner of living. So distributions that a couple would typically use for their lifestyle or education or health. But for example, $100,000 distribution to buy a yacht would probably not fit within the ascertainable standard.
So that leads into who may in fact serve as trustee of these trusts. So you might have the spouse, you might have another family member. What are some of the other options?
Other options are obviously a corporate trustee, so a bank or a trust company. Those are often used particularly if we go to a jurisdiction like Delaware, which is pretty common because of favorable asset protection laws and good trust law. The other option is often somebody naming a business partner, an accountant, their attorney, sometimes a sister or brother of the settlor who are not beneficiaries of the trust. So it's an important part of the conversation with the client. And we usually spend quite a bit of time talking about trustee selection and what the pros and cons are of each of those different options.
Yeah, that conversation of the kind of control, wanting to control by being a trustee, wanting asset protection on the other side, wanting to give beneficiaries as much power or access to the trust. Those tensions between them, I agree, take up a lot of the conversation as we're designing these irrevocable trusts.
Yes, and you just raised a very good point, which is asset protection. A really nice feature of the SLAT is that if he is an entrepreneur, they're a partner or principal in their own business, or they're in a high-risk business with assets, for example, in real estate development, they can fund a SLAT with the spouse as a beneficiary, and that trust, if it's written properly, can provide significant creditor protection for those assets. And that's also another driving factor in these trusts.
Right, so that kind of goes into all of those things we just talked about go into jurisdiction selection, right? So you're building up the conversation with your clients, trying to find out their goals. Are they looking for asset protection? Are they looking for control? Which can help you decide where in fact to situs the trust.
That's exactly right, because the one area where there are fairly significant differences in trust law is asset protection, and certain jurisdictions provide much stronger laws that protect trust assets from creditors. And just a side note, these are always unknown creditors. In every state, it's not possible to put assets into a trust and avoid known creditors.
So as you've described a SLAT, it sounds great, right? We're creating a trust to use our exemption today. My spouse can possibly be a beneficiary, can be a trustee. We'll talk about the terms. Some clients then say, well, let's create a trust for each of us. Why don't we talk about that for a few minutes?
So exactly, the issue with the exemption in particular is that I have an $11.5 million exemption and my husband has an $11.5 million exemption. And although it's possible for my husband to give me his exemption and let me fund a trust, we can't do that if he's going to be a beneficiary of the trust. So what that means is that if I want to create a SLAT and name my husband as a beneficiary of that trust, I'm limited to how much I can put into that trust without paying gift tax to my own $11.5 million. So if a couple wants to make use of their full $23 million exemption, the wife needs to set one up for the husband, with the husband and the kids as the beneficiary, and the husband needs to set one up with the wife and the children as the beneficiary. So that again is to make sure that we're using these full abundant exclusions that we have right now. However, there is a principle under trust law called the reciprocal trust doctrine. And what that says is that if the trusts are mirror images of each other, then effectively the IRS can uncross the trust and state that you actually never made the gift at all and the assets are back in your estate. So it's very important that we think about how we draft a trust to make sure that they can't be uncrossed and that they're not in fact mirror images. Otherwise we really haven't accomplished anything.
Right, right. And so the most common ways of doing that, you know, we outline here,
Yeah.
but kind of come back to that design. The first one, the first and the last come back to that design feature.
Exactly. And as we talked about before, the spouse could be a trustee, perhaps even the sole beneficiary of one of those trusts, in which case the standard for distribution has to be limited to that ascertainable standard that we talked about. So perhaps the other trust has an independent trustee, a corporate trustee, or the settlor's brother or attorney. And the distribution is discretionary, that the trustee can make distributions to the spouse and or children in equal or unequal shares as the trustee deems appropriate. Those are very different distribution standards because the ascertainable standard, as we talked about, is limited to health, maintenance, education, and support. So very different, an important factor. I just mentioned in my example, different trustees, where one, the spouse perhaps is the trustee, maybe even the only trustee, but we have an independent trustee on the other trust. Another differentiating factor is something called a power of appointment. So it's possible if I create a trust for the benefit of my husband and children, that my husband can have a power of appointment to alter who the beneficiaries of the trust might be, or the proportions in which they may receive what's left in the trust after both of us have passed away. The powers of appointment obviously give a lot of control to that person that you grant the power to. Again, a very important differentiating factor in creating trusts that are not mirror images of each other. And then the other things that are important are just perhaps do them at different times, fund them with different types of assets. And oftentimes this happens somewhat organically because couples have all different kinds of assets, and oftentimes their assets are not all jointly held for reasons. So somebody, one person in the couple may have started their own hedge fund and they own their ownership in that company in their own name. Someone else may have inherited a property through their family and so own a piece of real estate in their own name. So oftentimes if we get a view of a full balance sheet, the different asset is just part of the conversation and not something particularly targeted, but it's certainly a helpful factor in differentiating trusts.
Absolutely. So kind of thinking from a summary standpoint, that we hear about the slats. It's a trust created for the benefit of your spouse and your descendants. It's designed maybe for access during lifetime, maybe for asset protection, and maybe for tax planning to use our current high exemptions, and to remove future appreciation from a grantor's estate. I think an important thing you just noted is kind of that the assets and the funding, important for the funds being, if I create a trust, that the funds I transfer to were my funds, because they're going to be my gift, and not my spouse's funds, where she'll be a beneficiary. So that also goes kind of into the choosing of the assets and the timing.
That's exactly right. And the more time that we have to do the planning, the stronger the structure will be to stand up to any scrutiny. As the clock is running on 2020, it's really important that couples who are interested in doing SLAP planning meet with an attorney soon, so that they can start thinking about these structural issues and have some space and time between the two trusts. And as you just noted, sometimes we need to retitle assets between spouses in order to make sure that a spouse has enough assets to fully fund their trust and use that exemption. And time is necessary in that case as well.
Absolutely. So any final thoughts there before we close out?
Just final thought being the timing issue. Obviously we can't foresee what will happen in the election, but we learned something really important in 2012 when we also had an open question about potential changes in exemption. And that is that it is possible for Congress to change an exemption mid-year and make it retroactive to January 1st. So although it's very unlikely any new Congress and administration could change the law in 2020, it's very possible in 2021. So we are recommending that clients create trusts in 2020 to make sure that we don't have to worry about legislative changes next year.
That's a great point. Well, thank you for joining me today. I think that was a great overall discussion on slats and kind of the need to think about them now, plan now, and most likely start drafting them now in order to take advantage of a gift in the near future. So,
exactly. Thanks, Mike.
thank you.